So, welcome to July. We'll take a break from Hurricanes, free agent news, or no news, whatever, however you want to term it, because the Atlantic Coast Conference welcomed in three more schools today officially. SMU, Cal, and Stanford are part of the crew. Florida State and Clemson are also still part of the league in spite of their legal maneuverings. David McKenzie, who is an intellectual property law expert. That's what he does, and I can't speak. I speak for a living. So let's get right to it. Florida State and Clemson have both been in court, and I keep hearing on Twitter how this was a win for Florida State, this was a win for Clemson. We're basically just kind of been haggling over where as opposed to what, haven't we?
Yeah, I think that's right. I don't think anybody can declare victory. There's no running down the hill in Clemson, South Carolina, and there's no, Chief Osceola is not spiking his spear at the 50-yard line at Doak Campbell Stadium. It's very much still, a matter that's in play that's been mostly fought over what's called jurisdiction and venue. But nobody has even come close to reaching the merits of whether the grant of rights agreement is a valid agreement, was a valid copyright assignment. So we are actually still in just the preliminary stages of this dispute. There are in both jurisdictions, not in South Carolina, I shouldn't say both, but in two of the three jurisdictions, you do have some matters that are on appeal.
Right.
You have the Florida State matter down in Mecklenburg County that is the Mecklenburg County that's on appeal to the North Carolina Supreme Court, and then you also have Hart, and this is only a smidgen, quite frankly, of the matter that is going on in Tallahassee that is on appeal to. They have a unique appellate system down there that's on appeal to the First District Court of Appeals in Tallahassee, and that's just related to the motion to stay. It's not related to anything like the jurisdiction arguments, personal jurisdiction, or subject matter. So we're still very much in the infancy of all these disputes.
So I know, just following you on Twitter at McKenzie, was it McKenzie Law, right? I just want to get that right, McKenzie Law. Just like, you have been critical of the judge in Florida, right? Judge Cooper in Florida of, taking like an inordinate amount of time, which, judging from the court system these days and judges' rulings these days, seems to be the order of business. It's more normal than not for judges to drag their feet. What benefit does this have to anybody if the judge is kind of, taking his sweet time?
Well, this is one thing I've have been historically in this dispute. Sorry about all these
notifications. Quite all right. It just proves that you're busy.
Yeah. Sorry about that. So when I started out this dispute, and I got those off now, Adam, but when I started off this dispute, I was trying to be as judicious and also mindful that, as an attorney with over 2 decades of experience at this point, I'm mindful that, judges are human beings, and,
right,
that they're trying their best in 99% of the cases. And, it's with great consideration and care before I took on criticizing Judge Cooper in Tallahassee. It's beyond, at this point, what's happened down there on what are really, I would argue, are rudimentary motions that do not require a whole lot of hearing time. And that, quite frankly, especially if this were federal court, would have been decided on what we call the papers, which is, we're not going to have an oral argument on this. We're just going to look at the affidavits and the papers submitted. Most judges would have resolved that on the papers and would have done so, quite frankly, given the complexities of the issues, in 10 to 15 minutes. This is a situation down in Florida that, by my count, has had 19 hours and 3 days worth of hearing time. And they still only have like part of the order of the motions practice resolved. It's a minutia of sort of the overall questions that are going on in these lawsuits. So yeah, I have, with great concern, been highly critical of Judge Cooper, but I don't think it's required 3 days. I definitely don't think it required 19 hours. I think you would have to look at the 3 motions that he has decided. One was the personal jurisdiction motion that was brought by the ACC, which I thought was incredibly weak. I think most commentators out there did as well. The ACC is subject to the jurisdiction of Florida courts. I mean, and the question there is, does it have business contacts with the foreign jurisdiction? Does it have sufficient contacts, and how deep do those contacts go? And the ACC has contacts coming out of its ears. And I mean, how many times has it held a tournament, whether it's volleyball, basketball, or a football championship in the state of Florida? It's almost ridiculous to even be questioning whether or not it's subject to the jurisdiction of Florida courts. So that was a layup, but it still took 3 days.
Right.
And the other motions practice, which was the motion to stay, that to me, I've been pretty critical about this before. I've talked to you before about it, Adam. You really look at the nexus of where everything happened in deciding a motion to stay and therefore venue. And that unequivocally was North Carolina. The Grant of Rights Agreement was negotiated in Greensboro twice, in 2013 and 2016. All the funds coming into the conference come through Greensboro, or now Charlotte. All these agreements were signed in Charlotte. So notwithstanding questions, academic questions of, sovereign immunity and the like, everything militated towards North Carolina. And then there's also, and I think it's really important for the listeners to understand that this is also Florida jurisprudence. Not even getting to questions of where the nexus is. Florida jurisprudence is very clear that he who files first gets to go first. And that was a concept that, quite frankly, Judge Cooper completely disregarded. Instead of relying on established Florida jurisprudence, he cobbled together, much like Florida State's second amended complaint, a variety of sources that were not, found a way to find sources that were not Florida jurisprudence. So instead, he relied on things like patent law, which is the exclusive jurisdiction of federal courts. It's not a state court issue. And then a variety of other sources for persuasive authority other than the state of Florida. So those two things were kind of layups, and why it required 19 hours and 3 days is a bit beyond me.
David McKenzie, McKenzie Law on Twitter, as we're talking about Florida State versus the ACC and vice versa. My first reaction when these lawsuits were brought to light was that this is entirely designed to get the ACC to settle. I think the ACC. I'm a dope. But I thought the ACC's legal position was stronger than Florida State's. But the entire thing was designed to settle. Are these tactics also designed to just keep running out the clock, so to speak, and finally get the ACC to maybe throw up their hands and give up? Or are there legal merits to what Florida State is doing? And then I do want to spend our last couple of minutes talking about, since we haven't really, where we are, on the merits of this at this point.
Yeah, I don't think he folded with the royal flush. And I have stated pretty clearly, and even in discussion with you, that the ACC's case is extraordinarily strong. You're talking about a situation where you have the presidents of both Florida State and Clemson who signed this agreement not once but twice.
Right.
So you have a signed agreement. And then the question becomes, was there quote unquote performance under the agreement? But what we mean by that, has there been payment? And I think that the questions in a deposition for James Barker of Clemson, John Thrasher, and Eric Barron of Florida State University would be, we received hundreds of millions of dollars under this agreement. So I think you're going to be able to easily establish a validity of an agreement. So then the question becomes, what defenses do you have to break this agreement? And Florida State has presented nothing, at least in their pleadings, to say, well, this was fraud, this was misrepresentation, the classical defenses that we use to get out of a contract. So why the ACC would fold at this stage, given the strength of their legal position, I think would be questionable to me. I wouldn't believe that they should. I also think, Adam, you probably understand that there's lots of schools involved in the ACC. As of today, we have 16 schools. We're about to have 18 schools with the addition of Stanford and Cal. And when you think about schools and their interests, both their long-term prestige interests and then their monetary interests as being a part of the conference, do they have an incentive to take less or to settle with Florida State or Clemson? And I think the answer to that is no. And then finally, I also think that the actual settlement number is in such question and dispute that even if Judge Cooper or the judge in South Carolina were to force the parties to a mediation, achieving a settlement at this stage, when we really don't know the value of those media rights at a time when sports media rights in particular are absolutely exploding. I mean, I think the NBA just inked a deal for like $96 billion. I mean, maybe off a couple of billions on that.
It's a lot of billions, yes.
A lot of billions. And so the actual value of these media rights at a time where people are cutting the cord, and that the only thing advertisers are willing to pay for are things that reaches the consumer either through social media, on the phone, or through live sports. Who knows what the actual settlement figure would be? So I think we're a long way away from that.
Yeah, I've said that the number can't be lower than $500 million, but it's probably higher than that if Florida State or Clemson wanted to settle. But man, don't my advice: don't get into a debate with Florida State fans on Twitter about this. They are positive that they have been wronged, and that the ACC and John Swofford specifically have been hiding the truth from everybody. So just to screw Florida State.
Let me interject real quickly. I think and I'm no John Swofford apologist, but I think that what Florida State brought up in their second amended complaint regarding John Swofford and his son was one of the lowest blows I've seen in all of legal pleadings. His son had nothing to do with this. And then they're relying on articles from 2010 and then even 2008 for a modern day dispute in 2024. It just doesn't follow. I get that the fans are enthusiastic and that are upset, but I don't think that Swofford, nor his son, nor the Raycom conspiracy has much to do with Florida State's monetary plight right now.
No, their biggest problem is that their neighbor down the road in Gainesville is going to be a lot wealthier than them without really doing anything athletically other than baseball has been pretty good. They haven't done anything athletically.
Have you ever used a neighbor? Have you ever used a neighbor's situation as an excuse to not pay something?
No, but that's what they're doing. But that's basically what they're doing. It's just jealousy. They have yacht envy here in Tallahassee. David McKenzie, we'll do it again. I appreciate your time. Congratulations to the ACC for growing beyond where they probably need to be. But thank you very much for your time, man.